is that you need to speed up because people are losing hope.
Hope, yes. Well, I don't think
that's a fact.
No, people are not losing hope. I'm not living in a bubble, right? I interact with Ghanaians on a daily basis, all right? They meet me and they tell me, thank you for the good work you are doing for this country. Ghanaians still have hope, and their hope will be, vindicated when we have convictions, when we have recoveries and so on. But it's a process that must be, followed through with diligence. All right. So, for instance, I've given you one example, DRIP. Okay. So, in the DRIP investigation, right, which started immediately after the submission of the report, it got to a point in time that, as I said, I needed GRA to confirm the tax evasion. I wrote to GRA in July of last year. I just got their letter back. Okay, this December. Now, how do I proceed to court without the participation of the agency that can confirm that the wrongdoing has occurred?
You said the same thing about the ghost names NSS scandal also. You had to get the Auditor General involved.
Okay. And even National Cathedral, for instance, I'm still waiting for the forensic report. I can't proceed to court on National Cathedral unless the forensic report is given to me. So for people like Domelevo, I'm a bit, surprised that they know that even when I have filed a case in court, okay, the speed of the case doesn't depend exclusively on me. It also depends.
But he sits there and he also reads reports that the Iyoko Attorney General has filed the process. They are being asked to make disclosures and they are found wanting. They can't seem to be ready. He's reading about the Edubuahin matter we spoke about a while ago, and the commentary is that your own witness is crumbling your case.
No. You see, what we have to understand is that, okay, first of all, criminal trial is a judicially controlled, process. So, for instance, the judge says, I'm giving an adjournment of 1 month or 2 months, and I plead with the judge, or my lawyers plead with the judge not to give a short adjournment, and the judge refuses. What do I do in that case? I can't compel the judge to give me a shorter period of adjournment. Then also, one thing that you in the media, you have to take account of and also, investigate thoroughly, is that there are misrepresentations coming out of court. Okay, bloggers are being paid to make it look like, our case is crumbling. All right, they misreport whatever is happening in court. They misrepresent it, to the people of this country. But as a media person, if you objectively look at the evidence that we have filed, you will see that we did a fantastic job, of digging into the case and then unearthing evidence of wrongdoing. So for me, Rome was not built in a day. Every criminal trial has to go through the due process, okay? And so if people like him are saying that I should speed up, yes, I will speed up, okay? But I don't want to speed up and then trip along the line. And the same people will say, well, you see, Ayine didn't do his work well. That is why he's tripping, right? So, yes, there are, a situation like what you have described where, in terms of the disclosures, okay, there is a delay in getting some documents, or there's or in submitting some documents to the court, okay, and then they blow it out of proportion. It's not unusual for the prosecution to say, look, we are looking at our documents. If you say we should make a disclosure, we have put all our documents that we want to use for our case in court. Now, if they are making demands on us, all right, for documents, and then we are preparing to give them the documents, we are putting those documents together, and time runs out on us, then they say, oh, our documents are not ready.
Yeah, but the point is that you should have been ready before that. Once you are putting them on trial, you should have had your
we have all our so for instance, they are making it look like we need to supply them documents to defend themselves. But it's not our duty to do so.
But it's a requirement of the law.
No,
that you put the person on trial, you disclose and give documents that the accused needs to have to them.
documents
and that must happen before the trial. That's why it's happening.
No, it's something. You see, there's a world of difference between, so what we have said in the docket and the documents supporting our case, right, has been disclosed. So, for instance, one of the demands that they made in the Dubois case was that we should disclose the interrogation, videos. All right. Now, that is not something that we were putting forward in our case. We have our docket built. We have all the statements of the accused persons, of witnesses, and so on and so forth. That was our case that we took to court. Then you say, okay, make available to us the, the interrogation videos. Okay, so we have to go back into our system and then upload. So, for instance, with some of them, they may be erased because we don't have, enough space to be able to preserve them, and so on and so forth. So we have to go back into our system and then make those, videos available to them. Okay, so those are the circumstances that they are talking about. They're not saying
someone like that, he's watching the space.
Yes.
And that's 49.1 million Ghana cedis.
Yes.
Right?
Yes.
That's a lot of money.
That is a lot of money.
At least the cases you have put out so far, that's the highest amount you are chasing. The NSS.
No, the buffer stock is 78 point
right.
something.
So just quickly about that one, then we'll move on.
Yeah.
When you say the media, and this is not the first time you are saying that,
yeah.
At your last press conference, you spoke about bloggers being paid
yes.
to misreport and mislead.
Yes.
They are reporting from the courtroom. For example, this morning, I had to ask you that we have seen that there's a letter that was written by the National Security...
the former National Security Coordinator. Yeah. Allegedly written by the former
confirming that he had authorized the opening of the accounts that you are indicting Edu Boaheng on.
Yes.
Then I referred to the Israeli company.
Yes.
You, in your charges, you say that he didn't deliver the cyber defense device
equipment, yeah.
But they write to say he has delivered it. If this is what the bloggers are reporting, and then your witness in court also confirming some of the things and they are reporting, what is it about somebody being paid or somebody doing misreporting?
Well, okay. So if there is a factual development in court, like the ISC letter, right, and you are reporting it, you have to be accurate with respect to its content. Okay, what did the letter say exactly about the equipment that was bought, right? Did they say that the equipment that was bought, the money came from the BNC, the private BNC account? Is that what they said?
What they are interested in is that
yes,
they purchase the equipment and it's been paid for.
And
you say it wasn't delivered.
Yes,
so until you explain here,
yes.
I didn't know that there were differences. There were supposed to be two devices.
Yes.
So maybe you don't blame the bloggers.
Well, I blame the bloggers because the able deputy made that case very clear in court that there were two pieces of equipment, all right? And one of our witnesses, the director of finance of the National Signals Bureau, made that abundantly clear in court that there were two pieces of equipment that are involved in this trial. One, the authentic, pages. One, equipment delivered pursuant to the authentic pages. And then the second equipment that we are talking about is the one that he, mimicked the other transaction in order to steal the money. All right.
You have said that already. It's the first time you are telling me, and I'm hearing also, that the letter that was written by the former security coordinator, you suspect is fake, is forged.
Yes.
So you can't blame the reporter. They see the document and they say the name of the game is evidence.
Yeah. Okay, so yes, so a letter was written, right? What are its legal implications? Okay, and I'm saying that, first of all, we suspect that letter was forged, okay, or it's a forgery. It's a fake document. Secondly, we are also saying that even if it was an authentic letter, all right, the dead man was a co-conspirator in a criminal enterprise. And if he were alive today, I would have arrested him, added him to Edu Boaheng to prosecute him, because they are not supposed to do what they did. That is against the public, financial management laws of the country. It is against even their own signal bureau, laws. You see, I was talking with one person who told me, he has a former security couple, told me that, you see, national security, you don't investigate them because even if they take the money and throw it into the Kole Lagoon, you can't do anything about it. I looked at him in the face and I said, you know what? If any national security person takes our public money and throws it into the Kole Lagoon, I am going to arrest them and I'm going to prosecute them for causing damage to public property.
The question has been asked the question has been asked, who is the complainant in this matter? Has the national security complained to you that they have lost the money?
No, I don't need a complainant to be able to bring criminal, prosecutions.
Okay. Now,
I don't.
You are heavily criticized.
Yes.
What has become your frank, press conferences have also become a hallmark of your tenure.
Yes.
But your critics argue that you sometimes pronounce the suspects guilty. This clearly undermines the constitutional presumption of innocence and the human rights of the accused persons.
Okay. So what is wrong with a prosecutor telling the public what he has found? There is absolutely nothing wrong. And in none of those press conferences have I said that the person is guilty of the offense. I just lay out all the facts and some of the evidence to give Ghanaians a taste of what, I have been able to unearth.
You don't have to use the word guilty. When you talk about the buffer stock and others and you say, I cannot see how they can escape this. This is a betrayal of the public trust and all of that.
Yes.
That's tantamount to pronouncing them guilty.
Well, but
something that a court should do.
But you see, if a prosecutor doesn't believe strongly in his case, he shouldn't take it to court. And what I do is simply to, express strong belief in the case that I'm sending to court. All right. The people who criticize me, I don't know whether they watch TV. If they do, prosecutors in America, they lay out the charges, they lay out the facts, they sometimes even touch on the evidence and so on. And America is a democracy of over centuries, over 200 years. We are a democracy. The Fourth Republic, has lasted for just, 30-something years now. All right. So I don't know why in a democratic system of government, a prosecutor cannot tell the people what he has been able to find, especially when the crime is against the Republic. Okay. So what I'm doing is not, trying anybody in public, just simply putting out the case so that the people of this country know it best.
You have put up about 10 cases so far.
Yes.
Are you going to continue these press conferences for potentially 2,000 cases?
Oh, no. I will continue the press conferences to the extent that I do an investigation and I unearth, acts of criminality by any public official. I will have to announce it to the people of this country. I'm not going to stop today. I won't stop tomorrow. All right.
You're getting sued over these things.
No. Nobody can sue me for what I say.
You have been sued. You have been sued. At least Comrade Ibrahim's lawyers have sued you.
Ask him where the suit is. All right. How can you sue, the Attorney General for announcing a criminal investigation, right? And what defamation suit can succeed on, when on the face of it, there's credible evidence of wrongdoing. You and I, as lawyers, are arguing about what he did because, objectively, you agree that there's an act, that ought not to have been, done. The question whether he is guilty of criminality is one that we leave to the court.
Okay.
All right. But the fact that we are arguing about it means that there is, a credible evidence of wrongdoing that has occurred. All right. And so, for me, I don't see how anybody can succeed.
As you say, there are teams
suit.
And special teams and secret so-called teams that are trying to help you, even offshore and so on. We're human. Some will make mistakes.
Yes.
So when you are leading the prosecutions, don't you give yourself the benefit that potentially you could be wrong?
Oh, yes, I do.
So
and
if you make the pronouncements you make at these press conferences, and then later things turn out differently, what are you going to do?
Well, if the court says objectively that my evidence doesn't stand up to scrutiny, so be it. I will accept it. Or if I don't agree, I will appeal. All right, that is how the law works. The due process must take place. Now, but I have to be first of all confident in the cases that I bring before I step into a courtroom. And I said that at the beginning of my tenure, that if I don't believe that wrongdoing has taken place, I will not prosecute anybody just because of politics.
Right. Iyoko, there have been calls for you to advise them against using bail as punishment.
Yes.
Do you believe Iyoko is in the wrong in imposing hefty bail, conditions that keep the suspects in custody? And for some situations, we have seen people spend weeks, people spend months in custody.
Well, you see, I said before, and I'll say it again. It is the huge sums of money that we are dealing with. And you and I know, all right, that the bail bond must mimic, significantly the sum that is involved in the trial, just so that if you want to extreat the bond, if the person becomes a flight risk and you want to extreat the bond, right, you can, obtain significant amount or significant property in order to extreat the bond. So that is the reason why, they do that. But I have had occasion, and you are right, I've, advised them that the bail should not be, where they know, for instance, that a person is not a flight risk, okay, they should not impose bail conditions that will keep them, that will curtail their liberty.
In fact, the fact that the courts are slashing down these bail terms is evidence that they have been harsh
but if you,
and unfair to these suspects.
If you take what the courts are doing, the courts are responding to bail, review applications. But you can tell in the National Service case, the initial bail, bail imposed by the judge, not us, all right, imposed by the judge,
Rather went up.
They went up.
Right.